Hi, my name is Roger Haig with Gateway Pacific Law Group. Welcome to Gateway to the Law. We're an employment and workers' compensation law firm based in Long Beach, California. We're dedicated to advocating for workers' rights. My friend Jarvis and I are going to be talking about a somewhat disturbing subject, sexual harassment at work. With downsizing, greedflation, shrinkflation, companies are finding more ways to increase company profits for shareholders and executives at the cost of employees and consumers. And then, on top of all of that, some male and female workers are also having to deal with sexual harassment at work.
That's right, Roger. Some companies today are just plain shite. So, we're here to talk about an incredibly important topic: sexual harassment in the workplace under California's Fair Employment and Housing Act, also known as FEHA. We'll also debunk 5 common misconceptions that many people have about sexual harassment. So, let's dive in. First, let's summarize sexual harassment under California's FEHA.
Let's clarify what we mean by sexual harassment under California's FEHA. Sexual harassment includes unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature that affects an individual's employment, interferes with their work performance, or creates an intimidating, hostile, or offensive work environment.
What a wonderful explanation, Roger. Well done. Next, let's debunk some common misconceptions. A common myth is that sexual harassment is only physical. This isn't true. Harassment can be verbal, like making inappropriate comments or jokes, or even nonverbal, such as sending unsolicited, sexually suggestive emails or texts. Another misconception is that the harasser must be of the opposite sex. Sexual harassment can happen to anyone.
That's right, Jarvis. FEHA recognizes that harassment can occur between individuals of the same sex, different sexes, or any gender identity. What matters is the nature of the conduct, not the gender of the individuals involved.
Some employees believe that only their direct supervisors can be perpetrators. That's not true. Under FEHA, a harasser can be a supervisor in another department, a coworker, or even a non-employee like a client or vendor. The law covers a broad spectrum of interactions in the workplace.
Another misconception is that a single incident of harassment isn't enough to constitute sexual harassment. This is false. If the conduct is severe enough, even a one-time incident can constitute harassment under the FEHA. It's about the impact of the action, not just the frequency.
The final misconception we'll talk about is that filing a complaint makes things worse. Many employees are afraid that filing a complaint will only make things worse. While retaliation is a concern, California's FEHA includes protections against retaliation for reporting harassment or discrimination. It's important to know your rights and to seek help if you're experiencing harassment.
If you or someone you know is facing sexual harassment in the workplace, it's crucial to understand your rights under California's Fair Employment and Housing Act. Here, at Gateway Pacific Law Group, we're committed to protecting those rights and ensuring a safe, respectful workplace for all. Don't let misconceptions stop you from getting the help you need.
On behalf of Gateway Pacific Law Group, thank you for watching. If you have questions or need assistance, please don't hesitate to reach out to us. Don't forget to like, share, and subscribe for more informative content. Together, we can make a difference.